Discussed about 10th schedule of the Indian Constitution, often called anti-defection law, was introduced in 1985 by the 52nd Constitutional Amendment. It aims to curb political defections and ensure the stability of elected governments. Purpose: to prevent elected officials from switching parties after elections, often for personal gains. To maintain the integrity and stability of the legislative bodies. Ground for disqualification: a member of a house, parliament or state legislature can be disqualified if they voluntarily give up their party membership. Disqualification can also occur if a member votes or abstains from voting contrary to the party's directions. Exceptions: the original schedule allowed for exceptions like a split within the legislature party, one-third of members forming a separate group, and merger of the political party with another, provided it was approved by two-thirds of the legislature party members. However, the split provision was after omitted in 2003 to strengthen the anti-defection law. Key terms: whip, a member of the legislature party appointed by the political party to ensure members vote according to the party's directives. Political party: the entire organization including legislatures. Legislature party: members of a political party in a specific house. The 10th schedule of the Indian Constitution, popularly referred to as anti-defection law, was inserted by the 52nd Amendment 1985 to the Constitution. Defection has been defined as to abandon a position or association, often to join an opposition group. The anti-defection law was enacted to ensure that a party member does not violate the mandate of the party, and in case he does so, he will lose his membership of the House. The law applies to both Parliament and state assemblies. The anti-defection law aims to prevent MPs from switching political parties for any personal motive. Grounds for disqualification: if an elected member gives up his membership of a political party voluntarily, if he votes or abstains from voting in the House contrary to any direction issued by his political party, if a member who is independently elected joins any party, if any nominated member joins any political party after the end of 6 months. The decision on disqualification questions on the ground of defection is referred to the Speaker or the Chairman of the House, and his or her decision is final. All proceedings in relation to disqualification under this schedule are considered to be proceedings in Parliament or legislature of a state, as is the case. The anti-defection law punishes individual members of Parliament, MPs or MLAs for leaving one party for another. As per the 1985 Act, a defection by one-third of the elected members of a political party was considered a merger, but the 91st Constitutional Amendment Act 2003 changed this, and now at least two-thirds of the members of a party must be in favor of a merger for it to have validity in the eyes of the law. The members disqualified under the law can stand for elections from any political party for a seat in the same house. The decision on question as to disqualification on ground of defection are referred to the chairman or speaker of such house, which is subject to judicial review. However, the law does not provide time frame within which the presiding officer has to decide a defection case. If an elected member voluntarily gives up his membership of a political party, it may lead to disqualification, and if he votes or abstains from voting in such a house contrary to direction issued by his political party or any authorized to do so without obtaining prior permission. We already discussed about this. Affect the normal functioning of government. The infamous Aya Ram Gaya Ram slogan was coined against the background of continuous defections by the legislatures in 1960s. The defection leads to instability in the government and affect the administration. Defection also promotes house trading of legislators, which clearly go against the mandate of democratic setup. It allows wholesale defection, but retail defection is not allowed. Amendments are required to plug the loopholes. Different suggestions related to anti-defection law. The Election Commission has suggested it should be the deciding authority in defection cases. Others have argued that President and governors should hear defection petitions. Supreme Court has suggested that Parliament should set up an independent tribunal headed by a retired judge of the higher judiciary to decide defection cases swiftly and impartially. Then we can discuss some questions. Which one of the following schedule of the Constitution of India contains provision regarding anti-defection? We know this, 10th schedule. The 10th schedule was inserted in the Constitution in 1985 by the 52nd Amendment Act. It deals with the anti-defection law. Provisions as to disqualification on the grounds of defection. Decision on question as to disqualification on the ground of defection. If any question arises as to whether a member of a house has become subject to disqualification under this schedule, the question shall be referred for the decision of the chairman, or as the case may be, the speaker of such house, and his decision shall be final. Provided that where the question which has arisen is as to whether the chairman or a speaker of a house has become subject to such disqualification, the question shall be referred for the decision of such members of the house may elect in this behalf, and decision shall be final. The next question regarding anti-defection law in India, consider the following statements. The law specifies that a nominated legislature cannot join any political party within 6 months of being appointed to the house. So, cannot. This is incorrect. The law does not provide any time frame within which the presiding officer has to decide a defection case. Correct. So, 2 only. The 10th schedule contains the following provisions with respect to the disqualification of members of parliament and the state legislatures on the ground of defection. A nominated member of a house becomes disqualified for being a member of the house if he joins any political party after the expiry of 6 months from the date on which he takes his seat in the house. This means that he may join any political party within 6 months of taking his seat in the house without inviting this disqualification. Any question regarding disqualification arising out of a defection is to be decided by the presiding officer of the house. According to the law, the presiding officers have no time limit in which to deliberate on a plea for disqualification. The court can also only intervene after the officer has made a decision. Therefore, the petitioner's only choice is to wait until the officer has reached a decision. The 10th schedule of the Indian Constitution, also known as anti-defection law, was inserted by the 52nd Amendment to the Constitution in 1985. The anti-defection law was enacted to ensure that party members do not violate the party's mandate, and that if they do, they will forfeit their house membership. Both Parliament and state legislature are subjected to the law. Originally, the Act provided that decision of the presiding officer is final and cannot be questioned in any court. However, in Kyoto-Holohan case in 1993, the Supreme Court declared this provision as unconstitutional on the ground that it seeks to take away the jurisdiction of the Supreme Court and the High Court. It held that the presiding officer, while deciding a question under the 10th schedule, functions as a tribunal. Hence, his decision, like that of any other tribunal, is subject to judicial review on the grounds of malafide, perversity, etc. Third question. If any question arises as to whether a member of the House of the People has become subject to disqualification under the 10th schedule, the President's decision in accordance with the opinion of the Council of Union Ministers shall be final. This is not correct. Not President's decision. Chairman or Speaker of the decision is final. So this is incorrect. There is no mention of the word political party in the Constitution of India. This is also incorrect. Mention in Constitution. So answer is D. Neither 1 nor 2. The 10th schedule clearly states that in case of any question on disqualification under it, the decision is to be made by the Speaker or the Chairman of the House, nor the President. This is clearly provided under the 10th schedule. The President has no role in the disqualification under the anti-defection law, unlike disqualification under Article 102 and 191, which are decided by the President or Governor after consulting the Election Commission. Statement 2 also incorrect. The term political parties mentioned in the Constitution appears in 10th schedule, which refer to the role of political parties determine defection. For example, a member is disqualified if they voluntarily give up a membership of political party on whose ticket they were elected.